Our next presentation will be on reservoir development and the competing rights of horizontal and vertical developers. Our presenters are Mr. John Morrison and Mr. Wade Mann of Crowley, Fleck in Bismarck.
Thank you. We'd like to thank the Law Review for the opportunity to be here today, and thank you all for coming. This is a presentation that we did last summer for the annual Rocky Mountain Mineral Law Institute. It was in Newport Beach last summer, and so we basically are doing a reprise of that. I'm going to cover a few issues about horizontal development and its connection with what we've traditionally done in the industry called joint operating agreements. And then Wade Mann is going to cover some issues relating to some subsurface trespass issues that are kind of unique to horizontal drilling and Bakken development. If there are any questions as we're going through, feel free to raise your hand. I'll try to get you as we're going through, or there will be some time at the end, I'm sure. Just by way of introduction, horizontal drilling in North Dakota really started in 1987 in the Bakken Formation, but that was in something called the Bakken Shale. It was a completely different kind of drilling than what's going on now. By the mid-1990s, it was very heavily used in North Dakota in the Red River Formation in Bowman County. In 1995, there were 5,000 horizontal wells drilled in the United States. There were some wild predictions that as many as 10 billion barrels of domestic incremental recovery could be achieved through horizontal drilling, so it was causing a lot of excitement. By 2011, that 10 billion barrels of incremental oil had been increased to 24 billion barrels of oil and 750 trillion cubic feet of gas in an EIA report that came out. But by 2012, the oil and gas industry was estimating 24 billion barrels will be recovered from the Bakken Formation in North Dakota, Montana alone. This, again, is a presentation from last summer, so it's a little out of date, but things haven't changed substantially. In July of 2012, onshore, 57% of the rigs drilling were horizontal rigs. In North Dakota, the percentage is much higher. It's probably in the area of 95% in North Dakota, at least, are horizontal wells, and of those, the vast majority are in the Bakken. Most of the horizontal activity right now is in the Bakken, which we define as including the Bakken and Three Forks intervals. Because of the length of horizontal wells, spacing in the Bakken is very large. There are 1,280-acre spacing units for most wells. And when you combine 1,280 acres of minerals in North Dakota, you end up with a lot of owners. That's because the ownership has been fairly fractionated, and you do end up with a lot of owners over a 1,280-acre area. And so an issue comes up immediately: how do you deal with that many owners in an area? A JOA is a very common term in the industry, and it refers to a joint operating agreement. A joint operating agreement is a form of agreement that's traditionally been used in the oil and gas industry to govern the rights between co-owners in the working interest or the right to drill and produce minerals. In 1956, the first standard form of JOA was adopted. There have been subsequent forms in 1977, 1982, and 1989. You'll still see a lot of 1982 forms being used. Some companies have moved over to 1989 forms. It's been a long time since there's been a rewrite of the JOA, and there is no rewrite that's been done since horizontal drilling became as prevalent as it is today. There are a number of standard provisions out there which are typically included in it's the other provisions part of a JOA. A JOA has a whole list, it's a form of agreed upon terms, but there's something called other provisions at the end, and it's very common to have some pretty extensive provisions, including the other provisions, and there are a lot of specialized provisions that relate to horizontal drilling. Now, a JOA used to be the standard way business was done in the oil and gas industry. What a JOA does is it establishes a contract area. That's a geographic area that's going to be developed by the parties to the JOA. It provides for the designation of an operator, one of the working interest owners, to act as operator on behalf of the other working interest owners. It provides the means by which the owner might be removed and a new operator selected. It provides for the allocation of expenses and production from the contract area. Provides for the conduct of the initial operation and for subsequent operations. Typically in a JOA setting, the understanding is that all parties to the JOA participate in the first well. That's the initial operation. So the agreement is all parties will participate and pay their share of expenses. And then there's an Exhibit A that sets forth the interests of the parties in production, and that's generally their interest in the payment of expenses also. Subsequent operations might be subsequent operations on that first well, in other words, a rework or a redrill of the first well, or it might be drilling subsequent wells on the contract area. A typical JOA provides that any party to the JOA can propose a subsequent operation. When it's proposed, parties can elect to participate or not participate in that subsequent operation. If they elect not to participate, they're carried at a penalty. That means that the operator pays their share of expenses and recovers as a penalty, or as sometimes called risk compensation, a multiple of that share of expenses. Typically, it's, for many years it was 300%. So you would recover 300% of the non-consenting owner's share of production if they elect not to participate. Lately that's increased to 400% and 500% are very common. JOAs also provide a method for collecting payments due the operator, provides for liens that the operator can assert against non-operators. It provides for limitations on how wells can be abandoned and whether or not there can be conveyances of interest, partial conveyances of interest. Some JOAs attempt to keep all the parties to the JOA whole. In other words, you can't subdivide your interest in the JOA. Again, JOAs used to be very standard in the industry, in the Bakken these days, and it's becoming very common nationwide in resource plays. And by resource plays, we mean plays like the Bakken, where you're primarily drilling horizontally, where you don't have the same risk concepts involved that you do in traditional oil and gas development. But it's become very common that JOAs are the exception rather than the rule. I would say it's a very small minority of the cases where anything approaching 100% of the working interests are actually committed to a JOA. So what are the alternatives to a JOA? In most oil and gas producing states, including North Dakota, we have something called forced pooling, or compulsory integration is what it's called in the statute. That's found in section 380808 of the North Dakota Century Code. Compulsory pooling basically pools or joins together all the interest owners in a spacing unit and provides that all those interest owners get their proportionate share of production from the spacing unit, but also obligates all those working interest owners to pay their proportionate share of the just and reasonable expenses. What the statute provides is that pooling must provide an opportunity to recover or receive without unnecessary expense his just and reasonable share, or just and equitable share. So what are commonly provided in forced pooling statutes, or what are the options that are provided to the non-operator? One is to participate in the well. The operator, proposed operator, will send the non-operator, and usually it's something called an AFE, authorization for expenditure, that proposes to drill a well and says, we're going to drill a well, it's $10 million, your share of drilling costs is $1 million, please sign below and say you'll participate. So they can participate. Sometimes they have the option to surrender the working interest for a bonus. In other words, you basically sell your working interest in the well and you receive a cash payment in lieu of that. There used to be something called a farm out, was very common. A farm out was a provision or was an agreement whereby your interest would be carried under specific terms. Usually you would retain a cost-free interest and would back in after the well paid out for a proportion of your original interest. But now it's very common to have statutes that provide for carrying interest at a penalty. And what that means is, like we talked about before on subsequent operations under a JOA, North Dakota's pooling statute provides that if an operator drills a well and some of the non-operators elect not to participate in the cost of drilling that well, the operator can recover a penalty. And the penalty in North Dakota is 200% of the reasonable actual cost of drilling and completing the well. Now so the operator recovers 100% of the actual cost plus a 200% penalty, or a 300% recovery for owners that are subject to an oil and gas lease, lessees. If it's an unleased mineral owner, the unleased mineral owner gets carried at a 50% penalty, meaning 150% recovery for the operator, and the unleased mineral owner also gets a cost-free royalty before payout. So there are advantages to being an unleased mineral owner in North Dakota. You get some pretty favorable terms in a proposal. Another provision that some statutes allow is to be carried at no penalty, or what we call a free ride. In North Dakota, that was the norm up until the late 1980s when the legislature did authorize a penalty. This being carried at a penalty, though, has pretty well eliminated the farm out concept, where the operator does not have the same incentives to allow a farm out or to negotiate a farm out that they used to have. And so it's pretty rare that you see a true farm out agreement anymore. The Arkansas alternative, what I'm going to talk about in a few minutes is when you just have a pooling arrangement and somebody is force pooled into a well but doesn't sign a joint operating agreement, there are a lot of questions about how the well is administered, how the operator is selected, how financing is arranged, how gas balancing is handled, how insurance provisions are handled. There's a whole range of questions. There is an alternative in Arkansas. Arkansas, by rule, has said that they've prescribed a form of joint operating agreement. And they've said that in Arkansas, when you're force pooled into a well, your option is to participate subject to the administratively described form of agreement or be carried at a 400% penalty. And the penalty varies from order to order, but 400% is pretty standard in Arkansas. The Arkansas form includes an Exhibit B, which is a deemed lease. A deemed lease means that if you have unleased minerals, you get a royalty share and the rest is working interest, and it's deemed to be subject to a form of lease that's attached to the joint operating agreement. It includes a gas balancing agreement. A gas balancing agreement is a provision that provides how the parties are going to handle what happens when one party gets out of balance on gas. Basically, it's not uncommon in wells to have different contracts for different owners in the well, and sometimes because gas can't be stored, you get out of balance, where one operator or one producer in a well might have sold more gas than they're entitled to under their share, and the other owners have to have a way to catch up. The gas balancing agreement is a mechanism for allowing that. It also generally provides for a gas marketing agreement, and gas marketing agreement is what prescribes the terms under which the operator will market gas for the non-operator. Marketing gas is a much more difficult issue than marketing oil. Oil can be stored in tanks, oil can be delivered by trucks, and it's relatively easy to market oil, and it's not uncommon for non-operators to market their own oil. Marketing gas is more complicated. You got to have infrastructure, you've got to have a gathering system, and so it becomes more difficult to market your gas independently, and that's why there are a lot of issues about how the operator is going to market gas from a well. Now, in the absence of a joint operating agreement, how are the costs determined that the parties are responsible for? Generally, the pooling statutes, and this includes North Dakota, they provide that the non-operator is responsible for the payment of the costs of development and operation, and if those costs are disputed, the agency, and in North Dakota that agency is the North Dakota Industrial Commission through its Oil and Gas Division, determines the reasonableness of the costs. It's not that often, but occasionally there are disputes before the North Dakota Industrial Commission relating to whether or not a certain cost is a reasonable cost and can be recovered from the other operators. There's not a whole body of law in North Dakota. We'll talk in a minute about some of the law in other jurisdictions. First of all, Industrial Commission orders, whether spacing orders or pooling orders, are basically judicial orders or at least quasi-judicial orders. There is some semblance of res judicata that attaches to those orders, or some finality. The commission can't just come in and modify the orders at any time. There has to be a reason for doing it. Generally, modification requires a change of conditions or a change of circumstances. The commission generally expressly reserves jurisdiction to resolve disputes over costs, and there's also generally recognized implied authority to modify pooling to accommodate subsequent events. The Benyon case, which is cited, is a Utah case. What happened in that case was in 1971, the Utah Commission established a 640-acre spacing unit and authorized one well. In 1981, there was a pooling order that provided for pooling for the first well and authorized a non-operator to back in after payout. That means when the operator recovered its share of expenses, the non-operator could back in. In 1985, the board authorized a new well, so this would be an additional well on that 640-acre spacing unit. And the issue was, how will the non-operator be treated in that new well? And what the court said in Benyon was that the commission had the implied authority to modify its pooling order to accommodate the new well. And so the commission could, in that case, provide for a penalty situation in being carried on the new well. Another issue that gets complicated in these matters is the issue of public versus private issues and what the jurisdiction of the commission actually is. The commission is not a court. The commission does not have jurisdiction to resolve contractual disputes, to determine property matters, but it really has some regulatory jurisdiction, and its authority is limited to exercising that regulatory jurisdiction. There can be some fine lines over whether a certain matter involves regulatory matters or involves private rights. Constantine versus Martin is a 10th Circuit case involving Oklahoma law. The issue was whether or not an overriding royalty owner was entitled to take gas in kind. And that was important because if you take in kind, you're taking free of the expenses of operation. What the 10th Circuit said in that case was that the commission did have the authority to determine whether the overriding royalty owner was entitled to take in kind. Now the claim was, well, you're determining property rights, and that's a matter reserved for the courts. But the court said, no, you're really interpreting the provisions of the pooling, and that's a regulatory matter. Morgan versus Oklahoma Corporation Commission, the Oklahoma court said there was no jurisdiction to determine whether or not surface use was reasonable when the issue was an implied covenant in an oil and gas lease to make reasonable use of the surface. There the court said, now you're interpreting a contract, and that's a matter exclusively reserved to the courts, and the commission doesn't have jurisdiction. In North Dakota, there's really only one case that addresses this at the present time, specifically with respect to oil and gas matters, and that's Come Big or Stay Home versus EOG Resources. In that case, the operator conditioned the release of well information on the non-operator either signing a joint operating agreement or signing a separate non-disclosure agreement. In other words, a confidentiality agreement. The non-operator objected to this, went to the commission a couple times and complained to the commission. The commission said it didn't have jurisdiction to resolve the dispute. The operator then sued in state district court. It was not an appeal from the industrial commission decision. I think that's very important. It was a direct action against EOG, and it was brought on a combination of contract and tort theories. The district court granted summary judgment and said it didn't have, well, first of all, the district court refused to dismiss a case saying that it didn't have jurisdiction. The defendant argued that the court didn't have jurisdiction because the commission had exclusive jurisdiction. The court said, well, wait, I'm not going to dismiss this case when the commission has twice held that it doesn't have jurisdiction, and now you're saying the court doesn't have jurisdiction. Surely somebody has jurisdiction. But ultimately, the court did just dismiss on substantive provisions. When it got to the Supreme Court affirmed the summary judgment and basically dismissed the case. And in its simplest form, this case says that the commission, neither the commission nor the courts have jurisdiction to resolve this dispute over confidentiality agreements on participating in wells. I don't really think the case means that. It's just procedurally how it ended up in this case. The Supreme Court did not expressly address the agency jurisdiction issue. It was really only deciding the summary judgment case that came to it, which said that there was no implied contract theory, there was no joint venture or co-tenancy that they could rely upon, and there was no non-contractual right to receive proceeds, which was necessary to give rise to a claim for conversion. So I think the Come Big or Stay Home case has to be kind of limited to its facts and doesn't really resolve the underlying issue. If there is a dispute on cost when there is no joint operating agreement, again, the commission has a jurisdiction to determine the proper costs. There is an old Oklahoma case, and let me back up a minute. There's very little law in North Dakota on a lot of these issues, and that's not terribly unusual. North Dakota is a relatively lowly populated state. There's a lot of areas of law that aren't fully developed by judicial decision, and so a lot of times we're looking at what other states have done. Oklahoma's regulatory scheme is very close to North Dakota's, and when you look at the cases, you'll see a lot of times North Dakota courts tend to follow Oklahoma and Texas cases only because they have a long history of dealing with the issues. So that's why a lot of times when we talk about these issues, we look to the law in other oil and gas producing states, and Oklahoma and Texas have as much case law as anybody else. But this 1983 Oklahoma case says that in determining proper costs, the commission has to look at a two-pronged approach. It has to determine, first of all, was the expenditure reasonably required, and then were the expenses reasonable, assuming that it was reasonably required. And the facts in that case were that the operator tested unsuccessfully 7 different zones and incurred a lot of the costs. I think the well cost in that case exceeded the AFE by 4 times, so it was 4 times what was estimated. And that was largely due to this testing 7 different zones. The non-operator claimed that it wasn't reasonable to test 7 zones and it shouldn't be required to pay for those 7 tests. The Oklahoma Corporation Commission first said, we're not going to second guess the operator on whether it undertakes an operation. All we're going to look at is were the costs actually incurred and were they reasonable, assuming that it was reasonable to undertake the action. On appeal, the Oklahoma Supreme Court said that it is a two-pronged approach, that in making this decision, the commission has to look at, was the action in and of itself reasonable? In other words, was it reasonable to go back in and test those 7 different zones? And once it answers that affirmatively, then it looks at, were each of those costs incurred then actual and reasonable? New Dominion is another Oklahoma case, and this is kind of interesting. It has to do with a saltwater disposal issue. There was a saltwater disposal system that was in place, and the operator was using its own saltwater disposal system to dispose of water. And it had a fee that was charging third parties to use its saltwater disposal system. So in a forced pooling context, it charged a non-operator the same fee it was charging to third parties and said that's a reasonable fee, it's a reasonable cost. The court said, no, you're limited to actual expenditures, so all you can charge is a reasonable actual expenditures that you incurred in operating that saltwater disposal system and not the profit you're making in selling that service to third parties. The court did note that had the operator actually contracted with a third party and paid that same fee to a third party, it would have been an actual expenditure and then would have been recoverable. It was a fact that it was trying to charge that fee for its services it was providing that violated the statute. Another issue that comes up occasionally are AFE issues. AFEs, again, are the authorization for expenditures. Under a joint operating agreement, when a subsequent operation is proposed, an authorization for expenditure is sent to the parties and they elect to participate in that AFE. In a forced pooling situation, the operator is required to give the non-operator a reasonable opportunity to participate, and that's commonly done by sending an AFE to the non-operator, and then the non-operator elects whether or not to participate. The issue is that AFE really a contract? In other words, is it, if you're saying we're sending an AFE to drill a well that costs $10 million, does that mean you're agreeing to pay your share of $10 million? Generally, it's recognized that AFEs are at best a good faith estimate. Signing an AFE commits the party to a proportionate share of the actual costs. So if a $10 million well all of a sudden becomes a $15 million well because of cost overruns, generally the non-operator is going to be responsible for its proportionate share of the $15 million expenditures, assuming that it was the same operation, it was within the scope of what was proposed, and those types of things. But there are similar authorities saying that cost estimates included in a pooling order are good faith estimates and do not constitute a commission fixed limit of liability. In some states, Oklahoma is the case cited here, the Corporation Commission actually sets in its order what the reasonable costs of drilling the well are, and that's the terms upon which the non-operator elects to participate. North Dakota doesn't follow that procedure. That's kind of left to the parties, but when the dispute does arise, it will be over whether or not that AFE was a reasonable expenditure. Joint operating agreements also, as I mentioned, generally have marketing provisions. Under a joint operating agreement, the operator has the right but not the obligation to purchase and market the non-operator's oil and gas. Non-operators have the right to take their production in kind. There's a gas balancing agreement. The gas balancing agreement generally says either you balance in kind, meaning that an underproduced operator gets to take additional volumes of gas to make up for this underproduction, or you balance in cash, meaning the overproduced operator makes a cash payment to the underproduced owner. In the absence of a JOA, pooling statutes generally don't require an operator to market. There are some exceptions. In Arkansas, there's, again, the form of joint operating agreement that's imposed on the parties. That does provide a marketing agreement. Oklahoma has a market, it's called the Natural Gas Market Sharing Act, that basically obligates the operator to share its market with the non-operators in most cases. In North Dakota, there might be some issues because there are some common purchaser statutes that could become important, but generally there is not going to be an obligation on the part of a operator to market oil or gas belonging to the non-operator without a joint operating agreement. So if you do have a production imbalance, again, production imbalances typically come up in gas but could happen in oil. How is it resolved? I'm going to skip through this pretty fast and get Wade up here, but the long and short of it is that you have no idea how it's going to be handled. I've cited a few cases. The Louisiana case saying you have to balance in kind. That's 1994. 1992 Arkansas case saying you have to balance cash balance. You're limited to basically an accounting, which is a cash balancing situation. 1975 Oklahoma case saying cash balancing is required. 1978 Oklahoma case, again, cash balancing, but a 1992 Wyoming case saying in-kind balancing. I think what that tells you is that without an agreement, you're really taking your chances because you don't know what the court's going to say is reasonable or what the commission will say is reasonable in the first case and how the court will handle that. Joint operating agreements generally provide for how an operator may be removed for cause. Generally, under the earlier forms of agreement, if the operator fails or refuses to carry out his duties, he can be removed. Under the more recent forms, removal requires gross negligence or willful misconduct, which consists of a material breach or the inability to meet the standards of operation or perform its obligations. So there's a pretty tough standard in the more recent forms of joint operating agreement to remove an operator. But the contract does say how an operator can be removed and provides for how a successor will be chosen. Without a JOA, it's pretty clear that the administrative agency does have the ability to determine who operates a well. North Dakota has some regulations that deal with operations. Basically, it provides, there are 6 or 7 factors the commission can consider. The overriding factor is the size of interest. The presumption is that the party who owns a majority of the interest or has the support of a majority of the owners is entitled to be the operator. That's a pretty strong presumption. The commission has been pretty strong or pretty steadfast in implying that rule, and therefore it's provided some predictability, meaning that a lot of disputes over operatorship are really resolved when the parties sit down and realize who owns a majority. What about the relationship between operators and non-operators? Under a joint operating agreement, the parties have an obligation to act in good faith. There is no independent cause of action for a breach of good faith. Generally, a joint operating agreement provides an express agreement that it does not constitute a joint venture. So the parties do not become joint venturers by virtue of going into a JOA. Without a JOA, there's an excellent chance that you do have a joint venture. Now all of a sudden you have people jointly paying the cost of an operation for profit. It has a lot of the, it smells like a joint venture. And under a joint venture, there may well be some fiduciary duties that arise, and there could be joint and several liability that arises, which makes insurance a very important issue. If you're a non-operator and if you're participating in a well or not participating in a well, you want to make sure that either the operator's insurance coverage covers that non-operator, or if not, that you have your own insurance coverage, because you might have some broader liability than you thought as a result of joint and several liability that could arise from finding a joint venture. I'm going to skip over the next slide, and that brings us to Wade's portion of the program. I'm going to turn over to Wade.